Okay, my name is Jack Dearborn. I'm the chairman of the Weare Zoning Board of Adjustments. This is the November 3rd meeting. We have 3 cases to hear this evening. Let's see. We have case number 0715. It's continued from July. Michael and Diane Jurgen. We have case 1215, Judith Clementi, request for variance. And we also have a new case, is case 1315, Lass and Rochelle. I'm gonna butcher this. How would you like to do it? Kamnisi? Okay, I'll take your word for it.
All right.
Applicant. Okay, what I'd like to do, and the chair's gonna decide this, I'm gonna take the last case first. Because there's nothing simple in zoning, but on its face it appears to be somewhat simple. So I'm going to ask that case 1315. All right. Okay, before we do that, let me just explain how we want to do this. The way we run the meetings is we will take each case individually. The first case, a case will be taken. I will ask the board, well, first I will seat the members, and this evening for the first case is going to be these 5 members, and we'll introduce the board in just a second. But what we really want to do is make sure the board finds the application adequate to hear the case. That's step number 1. So we will ask for a motion to accept the case in order to hear it. Being in the positive, we will then move on, and I will ask the applicant to come forwards. Then I will ask the board if they have any questions to ask of the applicant before he or she goes through and reads the 5 points of hardship. Being none, we go through the 5 points of hardship. After that's done, the board is satisfied, no questions. We will ask approving abutters, disapproving abutters, public at large, or the boards. Once that's done, the applicant may get up again and rebut anything that may have been said. After that, I go around the room one more time. Approving abutters, disapproving abutters, public at large, other boards. At the end of that, I will shut down the public hearing, and then we as a board will deliberate. There'll be no input from the public, and we will deliberate on the case and make a decision. Then we go to the next case. So we basically take care of the case. When we do decide, the decision will be in writing in 24 hours, I believe. And then the minutes will be in writing in 144 hours, 6 days. So if you want to have a copy, come by and see Chip in a day or two, and you can get the decision in writing. Okay, with that said, members, for the first case this evening of 1315 is
Mark Moretti, member.
Stu Richmond, member.
Don Rogers, alternate.
Malcolm Wright, member.
Thank you. Okay. All right. Okay, I'd like to entertain a motion to accept the application for the hearing this evening.
I'll make the motion to accept the application.
And then it's case 1315. Correct?
Case 1315.
Second?
Second.
Thank you. Discussion? Any questions on the application before we hear it? Being none, all those in favor?
Aye.
Opposed? Being none, abstentions being none. 500. Alrighty.
Okay. This is a variance to construct an addition onto an existing house. And before I start, I'll just give you additional information. This is probably what you're really going to be looking at.
Is anybody here as an abutter or somebody that's interested in this case? Why don't you come on forward, March, just so you can see what we're describing to each other, so we don't have to go and somebody's raised their hands 10 minutes from now, don't know what we're talking about.
Yeah,
Something like this.
you saw. I'm gonna put these away because this has an additional stairway that's we added. It was kind of limited. So the existing house is right here. There's a 7.5 by 12-foot addition. These are the existing stairs right here. And where the stairs come down the side.
Yeah, this is just,
So
And we're gonna be pretty much right on that property line.
where is the house on 77?
Where is the house?
I wanna know where it physically is relative to,
The address?
I don't know addresses. Here we go, here's a little text map.
The house is, yeah, you're pretty far.
Oh, I see now, okay. And are you at 52 right here? Orange?
No, I'm on,
Yeah, that's it.
That you right here?
is that on Merrill
Merrill
Road?
Road,
Yes.
Yeah,
Okay, good. Now I know where it is.
okay. So,
Alrighty.
the addition is on that way?
Yes.
Okay.
Towards the road.
Now, while we're here, exactly what addition are they asking to put on?
What do you mean, what addition? It's a 7.5
Right, that's what I need.
feet out and 12 feet wide.
So it's a porch.
It's, no, it's gonna be an enclosed area.
Okay, it's a deck. Like
Well,
Closed
no,
deck?
it's gonna be a foyer, basically, foyer,
An entryway.
an entryway, foyer.
okay.
Because right now, as I'm gonna explain it, that right now there's a door, a steps and door,
Mhm.
and they walk in there and they can't even open the door all the way, it hits the stairs,
Mm-hmm.
and moving furniture in and out is real. And it's, you know, you have the door, you walk in, the weather comes in, so it's always nice to have an airlock when you walk into a house.
Okay.
And a closet, there's no, you know, this is a small house, 24 by 34, small house, no closet or anything, you know, no storage. Anyway. So I just kind of explained what we're, the whole,
Go through your
Addition
5 points of
thing.
hardship.
We'll go
Let me
through the
ask the board, do you have any questions of Art before we go through this?
no,
Okay, go ahead.
so that's basically what I was gonna explain is. Okay, so, point 1, that granting of the variance will not be contrary to the public interest because this is a private addition to an existing house. No public funds will be used for this project. This addition does not increase traffic or safety issues. The small addition will not affect the general public. Building the addition will not affect the functioning of State Highway 77, as has been confirmed verbally by Scott Looney from DOT. Number 2, the variance requested will not be contrary to the spirit of the ordinance because the structure was built in 1969, predating the ordinance by 2 decades. I do not believe that the purpose of the ordinance was to prohibit existing property owners from making minute additions to an existing structure, and variances are allowed to accommodate situations like this. Number 3, that through granting relief of the variance, substantial justice will be done because currently large pieces of furniture cannot be moved into the house because the stairway is too close to the front door. And the door cannot be opened without hitting the bottom step near the wall. The side entry cannot be used because that door is only 32 inches wide as opposed to 36 wide front door. The side entry cannot be widened without tearing down an existing portico above the door and the window next to it, which will all need to be redone due to the way they were integrated into the load-bearing wall of the structure. Number 4, that by granting the variance, the values of surrounding properties will not be diminished because this is a residential home with a proposed residential addition. The addition will increase the value of the house. The homes on both sides of the road are residences also. Residential use in a neighborhood that is also residential residential will not reduce values. Number 5A. Please describe the special conditions of your property that distinguish it from other properties in the area. The special condition of this property is that the entire house and garage are in this building setback. The 2 houses on either side of this lot and the one across the road are set back from the front property line. The correct, the 50-foot setback, they're correct. So then we've got AI. No fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property. The structure was built in 1969, predating the ordinance by 2 decades. I do not believe the purpose of the ordinance was to prohibit existing property owners from making minute additions to existing properties. To existing structure. The structure in question already has steps that extend 5 feet from the front door. This variance would only increase this area further by 2.5 feet, which is a negligible amount, and would greatly improve the usage of the structure. And 5II, and how the proposed use is a reasonable one. Without the variance, I cannot build a covered area in front of the house, meaning that I get rain and snowed on when I enter and exit the building. In the winter, the current front steps often freeze, making the use of the front door dangerous. It has been difficult to keep the steps clear through the application of snow melt and snow shovels because the large dormers that currently there cause massive snow accumulation on the front steps. And 5B is the same hardship. The whole house and garage are in the setback.
Okay.
And please indicate.
So how, are you done with your?
Well, I was going to just finish B.
Oh, go ahead.
Please indicate how owing to the special conditions identified above, your property cannot be reasonably used in strict conformance with the ordinance. Any variance is therefore necessary to enable a reasonable use of it. Strict conformance of the rule is a hardship on this property. The construction was done 20 years prior to zoning. A variance is necessary for the owner to enjoy a proper entryway into his house. That's it.
That's that. Okay, just so I get it straight. The front boundary is established by the state, am I correct? State road?
Yes.
Okay, so,
There's a law.
okay. So, when you, just so we get it straight, if we want to write the decision no closer than X feet,
I have the distances.
what is the real,
I have the distances.
what's the number you want? You're
Off the
looking-
property line?
Yeah, no closer than,
Be right on.
2/10 of a foot. That's what I have.
I thought, okay, just want to make sure I heard
It's
it
real,
right.
it's real close.
I see it here, I just
So what
wanted to
you-
make sure.
What you're doing is asking for an additional, from where the steps are, 2.5 feet to the outside wall of this new addition?
So, you protrude right now 5 feet from the house.
Yes.
Is that what I heard?
Stairs, yes.
Okay.
Stairway.
So, so is it fair to say you're you want to come 4.2 more feet?
No, 2.5.
2.
We're coming 7 feet off the house, and it's gonna be 2/10 of a foot from the property line. That's the bottom line, right?
You're basically coming off another 2.5 feet, right?
We're basically, yeah, and 2.5
Okay, so
feet from,
yeah.
from what exists as stairs,
Yeah.
as a stairway.
Now, is this the primary entrance as opposed to
Well,
side
the front
entrance?
door- Well, it's 2 doors, primary?
That's the front door.
Well, I have
It's the front
the reason I'm asking is I have a front door that I never use, and it's in the front of the house. It's never used. I use the side door.
I guess they use them both. Obviously, they're gonna spend money to build an entrance doorway there. I'm sure they're gonna use it.
Right,
It'll be
okay.
used. And the reason is because they don't have any closet. You walk in there, the door hits the stairs. You've got snow and, you know what it's like just having a door
Right.
on the face of a.
Well, I
building.
understand all those conditions. I was
Got
just
all
curious
that.
because you're showing one door, and there's more than one door in the house,
Well,
right?
there's another, there's a side door.
Okay, and yeah, you
We
mentioned the
side.
32-inch door on the side.
Yeah.
Yeah.
on the garage side, in the back.
Okay.
Okay, so you measured this, knowing
Yeah.
that.
Yeah.
It's 0.2 feet. So that we're not going to have a situation where they build it, they go to sell it, bank comes out, the surveyor's in and says, whoops, you're 0.1999.
I'm sure that Chip is gonna require a certified plan.
This is concerns we have.
That's probably a
where-
guarantee.
You know somebody?
As he should. That's this close.
Okay. Any questions from the board? All right. Why don't we, go around the room. Have a seat, please. Are there any approving abutters who wish to speak on behalf of the applicant? Come on forward. You need to come up to the mic. And state your name, please, Marge.
Marjorie Burke, I live on Merrill Road, I'm in a butter, and I have no objection to their little addition.
Any other approving abutters? Being none? Are there any disapproving abutters who wish to speak regarding this? Being none? Other boards? Being none, public at large? State of New Hampshire? Being none? You wish to get up, Art, and say anything? Thank you. Okay. At this point, I'm gonna shut down the public meeting, and we will vote on each one of the 5 points of hardship individually. We take the fifth one as a whole. With that said, let's have a motion to accept point one.
Move to accept. Point 1.
Thank you. Do I have a second?
Second. I'll
Any,
second.
any discussion? Pretty straightforward? Okay. All those in favor?
Aye.
Opposed? Being none, abstentions being none. 5-0-0. Next one. Somebody wants to move to point two?
Move to accept point 2.
Thank you. Second?
I'll second that.
Okay, thank you. Discussion? Being none, all those in favor?
Aye.
Opposed? Being none, abstentions being none. 5-0-0. Point three?
Move to accept point 3.
Thank you.
Second that.
Thank you. Discussion? Being none, all those in favor?
Aye.
Opposed? Abstentions? 5-0-0. 4?
Move to accept point 4.
Thank you. Second?
I'll second.
Thank you. Discussion? Being none, all those in favor?
Aye.
Opposed?
Move to accept 5 in its
Oh,
entirety.
second.
What? Sorry.
No opposed, no abstentions?
Oh, I thought you did that.
Okay, just want to make sure. 5-0-0. And just before we do the fifth one, I just want to make sure that the way we're going to write this up is that the residents can build no closer than 0.2 feet from the state line. That's the condition. So that's the way the variance will be worded. No closer than 0.2 feet.
No impact.
Thank you.
Move to accept
Five,
number
please.
5
Thank you. Thank you.
in its
Second.
entirety.
And a second.
I'll second.
Okay, discussion? Being none, all those in favor?
Aye.
Opposed? Being none, and abstentions being none. You got an early night.
Is that Mark is seconded on number 5?
Pardon?
Is that Mark is seconded
Yes.
on number 5?
Okay, you're welcome to leave. You can stay. Okay. Is this something you want to keep?
No. But if you'll pass it down here, I will
Dispose of it?
Get it back the way it's supposed to go.
Next case we'll have is 0715. This is Michael and Diane Durgan. Okay, let me just get something done here. The last time, I think back in July or was it August, we opened the meeting by accepting the application. And then we got into the meeting briefly and decided that I needed the board decided they needed to have some legal advice to review the case. That's been done. And on the way out the door, I asked the attorney for Durgan to consider rewording the questions on 4 and 5 because they were answered correctly, but they weren't exactly the question on our application. They were taken. It seems like all lawyers decide how they want to phrase it, and our lawyer did it slightly different than other lawyers would, but in order to make this a pure case and we're not going to get a challenge on a procedural issue, I asked that they resubmit the package, and everybody's got the new one on the board at least.
I know.
And
I'm not sure if I have the new one. Is the date on it?
that one.
This one.
Right there? Okay.
There.
Mr. Muller, you
Okay.
have the,
No, I'm for the butters, so
pardon me?
I'm representing one of the butters.
Yeah, I'm asking you if you have a copy of the latest.
Yes, I do.
I just want to make sure
Thank you.
parties weren't going to say a half an hour into this, what do you mean about our new application? So, with that said, I'm going to take the liberty to basically ask the board to accept this case. And for the purpose of the
Sure I
season,
do, I might have,
I'm going to ask
If I saw
Dawn,
that.
no, we're going to ask Dawn to stay here.
yeah.
And this is the board, this is the board that we're gonna hear the case, so you capture this, the same group of guys here. Okay, we have, another application. I believe all the language for the points of
This
hardship
is the
are the
old one
same.
here.
Yeah, I had
That
to
one?
tweak it just
Yeah.
a little bit.
Because I had it
So
the
that's
last
why we're
meeting.
doing this, in the event you did do that. Okay, so, this is the
Chairman?
application.
I'm not sure if I got that.
Well,
What's the date on that?
you got a
Is it-
staple driven through the front, looking like that?
That's the
Okay.
same date.
The same one that we had the last meeting.
Yes.
This is what I've got. I didn't get, okay,
Yeah,
the
let's
same
hand it out
one.
by chip.
Okay.
Okay.
Just
so we
making
make this
sure.
complete. There is a checklist.
Okay.
I think I've got the old one.
Well, let's get this straight before we get going.
Yeah.
Which is the one that you believe is the correct one, Chip?
The one with the letter on the front
Okay.
that says, this is the copy of the
Thank you.
requested document asked for by
Thank you.
zoning.
Are we okay now? I want to make sure.
I still think I have the old one.
Well,
That's
This-
the new one.
That one.
That one.
I had this at the last meeting.
That one.
he handed out the
You
last.
had it at the last
Okay.
meeting.
I got you.
Right.
Okay, I want to make sure.
Yeah, I thought there was another one.
No.
Okay.
There's an original, and at the last meet,
You handed out the last
September,
meeting.
or we.
That's why I have it, okay.
He
The
handed
only
it out.
reason it was not heard at the last meeting was that there were not enough
Correct.
members present for it.
Ah, okay, all right.
Okay, I want to make sure everybody's on the same page.
I'm good.
We have a checklist. We have a, we have a tax map, a list of abutters, and I believe there's another map that was, and a deed. And I believe there's another map. Okay, got the application. With that said, anybody have any questions regarding the package, so we can hear the case?
No.
Thank you. Okay. Motion, please?
Motion to hit, case 0715.
Thank you. Second?
I'll second that.
Aye. Being no discussion, all those in favor?
Aye.
Aye.
Opposed? Abstentions, 500. Okay. Now, if we see it, if we bring out any maps, I'm gonna ask folks to come forward who wish to see it, so everybody knows what we're talking about, and we don't get a question 2 hours or 1 hour into this. Hopefully it's not that long,
Okay.
but that will be the backup.
So for the record, my name is Maria Dolder, and I represent the Durgans. And to that end, I do have some colored photos for the board. I believe that you had received some photos with the engineering report, but they were not in color. So
I
do
have
these
a
pair of photos.
North Weare or something report. Here we go. Northeast Engineering. Here we go. So this is really augmenting what we have in there.
Yeah, it's some additional colored photos, and I do have a couple extra copies I can put
But-
here at the end of your desk if anybody wants to come up and.
But these
They're
photos,
different photos, those are photos taken by my client. with
right,
different
but they
colors.
don't correlate with these.
They're not the exact same photos, no.
Okay, thank you. Alrighty?
All right, well, since this is the first time that we've actually been before the board to discuss the application, I just want to give you a little bit of background as to why we're here. As you probably know, the Durgans obtained approval from the Town of Weare Planning Board to develop a 17-lot cluster subdivision. The subdivision is known as River Ridge, and that was approved in 2007. The approval became final in May of 2008. The property is located on Colby Road, and it consists of approximately 54.99 acres. It's located in the RA district. The subdivision provides for approximately 27.56 acres of open space and 1,600 feet of roadway to serve that subdivision. As of today, Lot 1 of the subdivision has been sold to a third party, and Lot 2 is occupied by the applicants. Unfortunately, subsequent to obtaining the approval, the applicants were sued in connection with this property and the subdivision. And that lawsuit tied up the property. The lawsuit was not settled until February of 2013. So that was a really long period of time in between the time that they got their approval and they were allowed to do anything on the property. Once that lawsuit was settled, the applicants proceeded to actively develop the property pursuant to their subdivision approval. In fact, they've worked on blasting, removing rock material, excavating the road to serve the subdivision. As you're all aware, the reason that we're here is because in March of 2007, the zoning ordinance was amended and changed the minimum lot size requirements in the RA district. It's clear that the River Ridge subdivision is only subject to this change if the applicants did not establish substantial development on the property, which governs vesting of subdivisions. It's also clear that even if they weren't vested, even though the time period goes, the subdivision doesn't just disappear. The subdivision is allowed to continue so long as they're still in compliance with the ordinance. So we're here today asking for a variance from the change in the zoning ordinance so that the applicants can proceed on the subdivision as it was originally approved. And since a lot of the points amongst all 5 of the variance requirements kind of overlap, I'd like to give you an overview of the key points that apply to multiple of them instead of just repeating myself over and over again. And obviously,
You still have to address all 5.
I will address them separately, but instead of repeating the same points, I'm going to try and hit the highlights that do kind of focus on all of them.
I want to be very clear.
Sure.
You can do anything you want, but we require you as the applicant to read the 5 points.
Oh, sure.
So effectively, it's heard by people that don't have this.
Absolutely, and I will do
And
that.
it is entered into the minutes. So
Absolutely.
your case will have that part of the minutes.
And I'll do that once I kind of go through the
That'd be
overview. I want to at least get out some of what I feel
That's
are the
fine.
big points to focus on. And obviously, at any point in time, just stop me if you have any questions. So the first thing I'd like to at least point out is that the applicants tonight are merely requesting that they be allowed to continue development in accordance with an approved subdivision plan. They're not asking for something new. This plan went through the planning board process, meaning abutters were notified at the time and had the option to come in and make comments to the plans. It was fully engineered. The planning board considered issues like traffic, drainage. All of that was taken into account by the planning board at the time of the subdivision. Nothing about that has changed. There's no reason to think that anything on that side of the subdivision application is any different today than it was back when they got the approval. It will still comply with all the health and safety regulations. So from a planning board perspective, they did look at this subdivision top to bottom. Second, this project has been regularly inspected by the town engineer, who at the time was James Donison. I'm not sure if he's still here. In fact, in July of this year, in anticipation of these board meetings, James Donison did visit the property again. He took another look at the progress. He issued a report, and all the reports that I've seen from him indicate that all the work done by the Durgans does comply with their approved plans and the applicable regulations. He indicated that the roadway progress is proceeding well, and so they've been working with him regularly. In going forward with the subdivision, if this variance is granted, it will continue to have to be inspected by the town engineer, whomever that may be going forward. So there is that check that they do have to continue to comply with their subdivision approval.
Just
This-
want to make sure.
Sure.
Everybody have a copy of this? You get this, I'll make sure the board has. It should be tied
David
back.
Aaron.
Yeah, I know, I've seen it.
Just want to
Yeah,
make sure.
I know, I've seen it.
So,
Yeah, no problem.
I just want to make sure if it's got the same.
No, that's fine. I'm okay with that. Third, this is not a situation where the applicants just sat on their rights and let the subdivision sit. They have been working on developing the project. They've been working actively, diligently, and in good faith on the approvals that they did get. As it's noted in Mr. Donison's report, they only have approximately 150 feet of the roadway left to remove. The rest has been prepared to the subbase elevation. So this is certainly not a situation where they got an approval and they just sat by. Unfortunately, they had some intervening things that happened that delayed their ability to start on the property. In terms of the zoning ordinance itself, and this will go to the spirit and intent of the ordinance, the use itself is permitted under the zoning ordinance. In fact, cluster developments are encouraged within the RA district. So even with the requested variance, it will allow this property to maintain a large amount of open space. It will help it to promote the conservation of natural resources and allow it to be used in a way that the zoning ordinance actually encourages. All of that was within the spirit of the zoning ordinance. As I said earlier, it will allow them to retain approximately 27.56 acres of open space that won't need to be developed, so this development can happen and have this large open space that's not going to be touched. And the fact of the matter is, the Durgans cannot develop this cluster without the variance relief. It's not financially or physically feasible at this point in time for them to move forward without the variance.
Let me just ask a question on this 27 acres of land. Has the town of Weare taken ownership of that 27 acres of land right now, or is it still in the hands?
Yeah, I don't think they've taken it yet.
Just wanna make sure.
I believe it's still in their deed. Which goes probably to your point of if this doesn't happen, the town won't get the open area because it doesn't already have it.
Well, yeah, I think it complicates the matters as far as, I just wondered if it was,
Yeah, no,
had
sure.
happened.
No, not yet. I think they wait until it's further
Okay.
developed. Another point is this property directly abuts a 29-lot cluster subdivision. It's one of their direct abutters. They have all of those lots within that subdivision are less than 5 acres in size. Clearly, this demonstrates that this is a reasonable use of a piece of property this large in size, and it is in conformity with a direct neighboring use. I know that the zoning boards are often concerned about setting precedents with variances. In this particular case, this variance itself will not do that. The fact of the matter is in 2012, the ZBA had granted a very similar variance to this already. So if any precedence has been set, it had previously been set, so this will not further that in any way, shape, or form. In fact, this request is very similar to the previous one, which was SHB Properties. In that particular instance, it was also another subdivider who it was questioned whether or not they were vested. They had not done any work on that particular property. So they came in for a variance from the 5-acre change in zoning as well. One of the things that I do think distinguishes this case from that case is, in that case, their only claim for hardship was financial. They had not performed any work whatsoever on the property yet, so all of they had some unfortunate intervening circumstances which prevented them from going forward, but their only claim of hardship that they could make was financial, and that was granted. This property is quite unique in a number of different ways. First of all, they do have a subdivision approval. So unlike other properties where you're trying to do something new, they do have a subdivision approval, and they're just trying to move forward on that approval. It complies with all of the regulations, including public health regs. The Durgans have not just incurred the financial cost of permitting, but they have put a substantial amount of money into developing this site. As I said, they've done some substantial work on the property, on the roadway, and they did it in good faith. So it's not a situation where they've gotten themselves into this because they took action that they weren't allowed to. I mean, they were supposed to be making this effort to diligently work on the property, and they did. And unfortunately, they've had some circumstances which prevented them from finishing. They've blasted approximately 650 feet of the 800 feet that's required. Like I said, they only have approximately 150 feet left of the roadway. You know, it's unfortunate if the lawsuit hadn't been filed against them, which stayed their work on the property, and they had some unfortunate issues with subcontractors along the way, the road would have been completed. So, given all of that, we do believe that we meet the 5 prongs of a variance. And I'll just stop here for a minute to see if anybody has any questions before I literally read each one of them.
Question from the board?
This time.
Seeing none, go ahead.
Okay, so number 1, the granting of the variance will not be contrary to the public interest because, as I stated in the application, in order to be contrary to the public interest, a variance has to unduly and in a marked degree conflict with the ordinance such that it violates the ordinance's basic zoning objectives. As I stated under the zoning ordinance, and I apologize for repeating myself, this use is permitted. It is actually encouraged in the district, and so this would not be in conflict with the zoning ordinance from that mindset. They have been actively developing the property, and so a large portion of this property has already been cleared and blasted, and they are only looking to move forward with a subdivision approval that was granted previously. The variance requested will not be contrary to the spirit of the ordinance because, once again, Article 27 of the Town of Weare zoning ordinance states that cluster developments may be permitted or required in the RA district. Clearly, this type of development is intended for this district, so under the zoning ordinance, it's permitted. The only difference clearly is the intervening change in the zoning ordinance from the perspective of lot size, but it still will promote other issues that the ordinance promotes, which are maintaining open space, promoting and conserving natural resources and features of the land, and so this will just allow that to happen. So therefore, it is in conformity with the zoning ordinance from that perspective. In terms of granting, that through the granting of relief by variance, substantial justice will be done. One of the rules that you look at when you evaluate substantial justice is that any loss to the individual that's not outweighed by a gain to the general public is an injustice. And clearly, under this standard, the applicants meet that. If this variance is not granted, they'll lose everything that they've invested in this project. You would have to start from scratch. And the ability of them to go back from day one to start the subdivision over is very slim. So all the work that they've put into it, all of the time and the effort and the money would be lost. And given that there is no gain to the general public that would outweigh that significant loss, they do satisfy substantial justice. And by granting the variance, the values of surrounding properties will not be diminished because, once again, they are proposing to develop this in conformance with a subdivision approved plan that they had submitted. It's on record. It will meet all of the planning board requirements. It will still have to go through all of the engineering, having the engineers check on their status to make sure it's complying with that subdivision plan. They won't be able to deviate from that, and as a result, these homes won't diminish the area. In fact, the intent of a subdivision like this clearly is to enhance the area. It fits in with the abutting neighbor, which has the 29 lot subdivision. It's gonna be very similar to that, but smaller. In terms of 5, an unnecessary hardship, in terms of the special conditions of our property that distinguish it from other properties in the area, once again, as I already stated, this property is unique. They obtained a subdivision approval for the property, but for the change in the lot size requirement, this cluster still complies with everything in the zoning ordinance and remains in compliance with your public health regulations. Unlike other subdivisions, these applicants have not just incurred the costs related to permitting, but they have taken active steps towards developing the subdivision, and they did that in good faith based on an approval that they had. No fair and substantial relationship exists between the general public purposes of the ordinance and the specific application of that provision to the property. As I stated a number of times, and I apologize, this is an approved subdivision, and clearly, although they have changed, obviously, the size, at the time, there was nothing to suggest that this subdivision didn't fit on this property appropriately. They were able to maintain a large amount of open space and still have the number of houses in a cluster to satisfy the planning board that they could meet engineering, drainage, and all of that. Nothing from that nature has changed. So there is no reason at this point in time that they shouldn't be allowed to go forward and just finish that subdivision. And the proposed use is a reasonable one. Once again, as I said, it abuts a 29 lot cluster subdivision that is clearly larger than this, but would be similar in nature. It maintains the open space, and the underlying use of the property itself is permitted under your zoning ordinance. In terms of Part B, my arguments are the same as what I just laid out for you in Part A. Do you want me to repeat all of that? Yeah? Okay.
If you wish it to be included in your testimony.
So the special conditions of our property that distinguish it from other properties in the area, once again, the property is unique because it does have a subdivision approval from the Town of Weare Planning Board, but for the change in the lot size requirements, the cluster subdivision still complies with all other requirements of your zoning ordinance, and it will remain in compliance with your public health regulations. Unlike other approved subdivisions, they've not only incurred costs related to the permitting, they have actually incurred hard costs of working on the land in connection with that subdivision. They've taken active steps towards developing the subdivision in connection with their approval. They've blasted approximately 650 feet of the 800 feet required for development of the subdivision, and that all the engineering reports to date show that it has been done in compliance with their subdivision approval. And this is the minimum relief that's required by the applicants in order to go forward with this subdivision. Without this approval, as I said, they can't go forward. Please indicate how, owing to the special conditions identified above, your property cannot be reasonably used in strict conformance with the ordinance, and a variance is therefore necessary to enable a reasonable use of it. I mean, as I've stated, without this variance, the applicants cannot move forward with this subdivision. They clearly can't do the cluster under the 5 acre rule as it's laid out at this point in time. This variance is necessary for them to move forward with that. It's not cost effective for them to try to do a cluster with the reduced size in lots, because they've put so much money into this project already. And so without the variance, they're going to be back at square one, and they're going to have to, everything that they've invested will be lost to them. And since they were moving in good faith towards trying to accomplish substantial completion of this, we're asking that you grant the variance that we have requested this evening.
Okay, thank you.
Any questions?
Being none from the board, may I have a seat?
Thank you very much.
At this point, I'd like to ask if there's any approving abutters who wish to speak on behalf of the application. Being none, are there any disapproving abutters who wish to speak?
Give me a moment, Mr. Chairman. Daniel Muller from Cronin Bissell Zielinski on behalf of Candace Lehman and Robert Kelly, who are one of the abutters. Before I get going, I do have a written statement that I'll hand out to the board. It will simply supplement what I'm going to say here. I'm going to hit all the points, but just so you can follow along, one copy for the record and one for each board member. I've also given one to the applicant's attorney. I'll try to keep this brief and to the point. From my perspective, the applicant sort of misses the point on a few things, and I'll start out with one of the statements that was sort of made again and again here about good faith expenditures. Vesting is controlled by statute or in the or under the common law. The specific statute is 674-39. And in this particular case, what they don't reference in their filings is they've actually looked at the vesting issue beforehand. In September 2012, Mr. and Mrs. Durgan filed an application with the planning board, specifically asking for an extension of the vesting period for this subdivision. The planning board on September 27, 2012 denied that application. In addition, on the advice of counsel, they ruled that they lacked authority to grant the extension, and they also said that active and substantial development necessary for vesting meant that the completion and the approval of the entire proposed road. Obviously, from the representations made here, that has not occurred. Moreover, they advised them that they had to have that done by April 23rd, 2014, excuse me. And so what we have here are representations that they've continued work after they knew or should have known, because the planning board told them their vesting period was up.
Can I hold you there for a second? Please?
Sure.
Have you, I actually have a copy. Do you have a copy? Okay, just want to make sure.
Yes. So, number one, as far as I know, that decision was never appealed, so it's final. So, as far as the Durgans are concerned, they have no vested rights. They disappeared in April 2014. If they've continued to work for purposes of law, they would not be considered to be acting in good faith. They'd in fact be acting at their own risk. So a lot of the argument here about what they've done and what they haven't done in terms of improvements, I think the board has to understand that issue was decided back in 2012.
If I've understood it correctly, they requested to the planning board, and the planning board does not have the position to grant that.
That was, on advice of counsel, that was their first ground. In addition, they advised them specifically to meet the vesting standard. They had to complete the road.
2014, April 20.
Yes, and that,
I got that, but what this basically says is, from Francis Bolton Chuck, Vice Chair, Weare Planning Board, it basically says, planning board lacks the legal authority to grant such extensions.
Mhm.
So it basically took it off the table. In addition to that, the board determines on advice of counsel that they need to get it done before April 23rd, 2014.
correct.
So I just want to be very clear that this is a document from the planning board, so.
So I guess from my perspective, one of the things they asked for in their application is to say that they're vested, and a number of their arguments are sort of based on that notion that they've acted in good faith. But again, to the extent that they've continued with work after that period of time, they've done so at their own risk. There's no good faith in terms of incurring any expenses at that point. Likewise, there's a request that this board grant an extension don't think this board has jurisdiction to grant the extension, number one. Number two, this is a subdivision approval, again, area for the planning board, not for this board.
If I understand it correctly, what they're asking for is a variance to the 5, from the 2008 change to zoning, from 2.5 acres to 5 acres. They're asking for a variance.
They're asking for a variance, but I think if you look at their application, they did have a couple of alternatives, basically assuming that it was necessary, they were looking for the variance. So they do have a couple of arguments in there that they should have been basically told that they had vested, and therefore can just go forward. With respect to the variance request, again.
By the way, Attorney Howard, because that is the notice of this evening, on the board, notice of the public, and the notice on the application, that is the only thing that the board can consider today. It would be interesting to consider the other ones, but it's not relevant because it's not an application before us.
Okay, very well.
Okay.
As I said.
I just want to narrow it so that.
No, I'm going to go into the variance points anyway at this point. With respect to, I'll address both the public interest and the spirit of the ordinance, because under the law, they are generally dealt with together. The notion here is whether this variance request unduly conflicts with the purposes of the zoning ordinance. And there was in arguing a lot of these points, there was a focus on the fact that this was a cluster subdivision. I think that's the inappropriate focus. The focus here is on the lot size requirement. And in 2007, the town changed from a minimum lot size based solely on soil types and slopes to one that not only had that, but also had a 5-acre minimum. If you look at an earlier subdivision of plan of the Durgan's property, this is B plan number 31488, it shows that at the time that that was approved under the soils, the lot size allowed was a little under 2.5 acres. So you're basically talking about double or half the density, depending on how you want to look at it. And clearly the 2007 amendment, we're talking the RA zoning district here, was looking to make it more rural, preserve that character without having these smaller lots. And what they're asking for today is, no, allow us to have the greater density, essentially twice what would been allowed, what's allowed on the current one in terms of lot size, so that we can continue with a plan that got approved way back when. There's some reference to potentially another subdivision. To the extent that's a non-conforming subdivision, i.e. was approved prior to this amendment, I would note in the 9A LLC versus Town of Chesterfield case, the New Hampshire Supreme Court basically dealt with a similar situation where somebody essentially wanted to go back and develop property consistent with the old regime. And they said, no, the town has sort of spoken here, and they've decided they want it more rural. They want larger lot sizes in this case. I think that was similar to what was there, and therefore held that the denial of the variance in that case was proper.
I think the fine point I want to offer is it wasn't done in 2007. They had it as an application on the warrant to be changed in 2007, but it actually got changed in 2008 at the time.
I will stand corrected then. In 2008, it became effective. In terms of, now I've already made the point with respect to their issue that, you know, they've incurred all these costs, etc. Again, they should have known back in 2012 what the cutoff date was. They still proceeded at their own risk. I don't think that they can sort of take advantage of their work done after the fact to say that somehow, you know, they should get benefit of what the law considers not to be in good faith. In terms of substantial justice, I disagree that there's no public interest here. Again, the ordinance was specifically changed to make lot size larger in this district, make the character more rural. And that's the interest. And their subdivision, approved on the old regime, doesn't do that. It's much denser than what's currently allowed. And again, going to their purported loss, they talk about a lot of construction done, including some that was done after or when they knew or should have known they weren't going to be able to get vested and that this was going to be an issue. So if you actually look at the circumstances, substantial justice would not be done here if the variance was granted. In terms of diminution of value of surrounding properties, again, when people bought into this area after the 2008 amendment, they were anticipating larger lots with a rural character. That's what my clients were interested in when they got into this area. And to essentially allow someone to basically, after the fact, come in and say, no, we want something denser, that goes contrary to expectations. And when you do something contrary to expectations, based on what the law is, you're going to get a notion that, look, I'm not buying what I thought I'm going to buy, and therefore there would be a diminution of value. Finally, with respect to hardship, in terms of the unique characteristics that they talk about, those are essentially characteristics not so much of the property, but more of the circumstances of the owner. The fact that they had a subdivision approval in 2007, don't deny that, but the law says if you want to take advantage of that, you've got to do certain things within a certain period of time. They didn't do that.
Let me just touch on this, and
Yeah.
I just want to make sure I get it clear. The original subdivision was 17, correct?
Correct. That's my understanding.
And is it my understanding that they acted on 2 of those lots, because there are buildings on those 2 of those lots now?
I understand
I know there's a building on one.
Okay. 2.
Looks
Okay,
like-
so the question is, we're not gonna do anything here tonight to disturb the 2 people that have built, the 2 individuals that built houses. Those are, any action we take, that has no effect on that. We are talking about the unbuilt on 15 proposed lots that have yet to be approved by the town for acceptance.
Essentially, that's what you're talking about. You're
I wanna make
essentially
sure.
talking, what this really is about in the context of a cluster subdivision is what they call the yield plan, which is how many lots can you get overall? And I don't think anyone would say it would be less than 2. The math doesn't support that, so I don't think that's an issue. It's just a question as to, in terms of the density of the other ones, how many can you get? And our position, obviously, my client's position, is that they should be stuck with what they're allowed to get under the current zoning, as opposed to
Correct.
going back to the old regime. So, no,
So it's really the 15 are up for grabs.
basically, yes.
That's kind of what I want to get to, because
Yeah.
we talk 17 as if it's the original. I just want to be very sure that people don't think that the current folks that have built before, whenever they did, they already have accepted buildings, and they are not part of this discussion. It may distort the final remaining, depending on how the board goes. I just want to be very clear that we're talking about the ones that have yet to be built on.
Correct. We're not here to argue that there couldn't be a subdivision of this property. It's just basically how many you can get in the end, and we're not talking that the 2 that are already done. And I think the only other point I'm gonna make in terms of the hardship is that essentially their argument at this point in time is, when they go back to the old subdivision looking for that, is they wanna maximize their profit and maximize their return. And if you look at the Harrington versus Town of Warner case, which is cited, the Supreme Court made it very clear that variance law doesn't serve to allow you to maximize your profit. You can get a reasonable return, and that's what you can get, but there's nothing to say that you have to get every last penny, and that's what we're talking about here. They're saying old regime because we want to get our 17 lots. And as I said earlier, in terms of fair substantial relationship, there is something here. Again, density requirements for this district change after the fact. And they're really looking to do something that's much denser than what's allowed here, and making them comply with the current regime, will be consistent, and will serve that purpose. That's what the town adopted, that's what they wanted, and we're simply asking that that be applied here. Unless the board has any questions, that's in essence our objection to this case.
Thank you.
Thank you.
Are there any other disputing abutters who wish to speak on this subject? Come on down, man. State your name and what lot you represent. We got a map. If you want to point to where you live, we think we have a map.
I'm right next to it.
Are you up the hill or down the hill?
I'm right next to the river,
Okay.
at the bridge in the river.
Okay.
My name is
And
Ann
what's
What's your lot number there? Do they have a lot? You have a mailing address?
364 Colby Road.
364. And your name, ma'am?
Ann Cummings. I'm certainly not going to be as eloquent as the lawyer, and I may not make the right points, but I'm going to try. A couple of things that come up to me is, yes, there was an original application way back when that I recall was 2+ acres on all of them, and maybe it got changed. There was a lawsuit that held things up. Whether it makes a difference or not, I do not believe the Georgians were successful in that lawsuit, so that was not helpful to them. All right, so they were doing something that wasn't supported in the lawsuit for their side. We are looking at rural. You're talking, there's already their house, the house that used to be owned by my in-laws used to own all that property, and then after they passed, it was sold. Part of the reason it was sold was because we were told it could not be developed because there wasn't enough road frontage, so it did get sold. My house and my in-laws all had to have 2 acres at the time that we got our property. And now you're saying, if I look at it correctly, what's here is 16 little lots, 1 that's over 2, I think 8 that are a little bit over 1, and then 7 that are under 1. This is a little teeny tiny, let's make this a little urban Manchester type of community. You're talking probably a minimum of 2 cars per lot coming out on a road that already has problems. We're talking the fact that we've gotten notice from the school that the school bus is so crowded that there may be days that they're gonna come down to us and say to my son, we'll come back for you because we don't have enough room because some of the high schoolers didn't drive to school today, so now we're short of space on the bus. We've moved the 4th graders over to the middle school, so you're talking, again, the possibility of 16 houses impacting the school district. It's just not maintaining, again, also the rural character. It is 5 acres now. That's the requirement, and this is not rural when you're gonna throw that many little teeny tiny houses in on a road. So, that's mine.
Thank you. Any other disputing abutters who wish to speak? Being none, we'll move on. Public at large?
We have one.
Oh, I'm sorry, I didn't see anybody's hand pop up. Your name, sir?
My name is Rich Hoenig, Hoenig.
And where do you live relative to this property?
341 Colby Road. I live across the other side of the road.
Got it.
But my objection is that we bought our property at a certain acreage and we pay taxes on that acreage. And I don't see why we should allow somebody to go against the ruling and have smaller acreage and pay less taxes in the same community for their property, not necessarily their house. And I have the objection also about the traffic. I don't see, I know I asked this question before and I was told that I should have gone on a planning committee, but I don't see why. We have a bridge that's a 1-lane bridge that, as far as I know, hasn't been serviced since 1972. We got a tremendous load of trucks coming over it now. And now we're going to add all of these people coming out of that road into Colby Road over the 1-lane bridge. I don't see why they couldn't have put a road to 114 direct. And I don't know the reason that they could have, not planned for that. Perhaps there is a reason, I don't know. I was attempting to find out, but I never did find out. But my point is that there's going to be a tremendous amount of cars coming out of that one little road, and that that they're going to go to River Road and not go all the way up the long way around to go up the road and avoid the bridge. As it is now, if a vehicle's coming the other way, one has to give. They can't pass if they're a certain width. Notwithstanding the fact that, like I said, as far as I don't know what the state of the bridge condition is. The state of the road, Colby Road, is not one to be praised about as it stands. So that's my objection.
Thank you, sir.
The fact that there'd be an inequity in the taxes and a tremendous burden on the road. And I guess the other lady pointed out that there's be a problem with the school busing of children.
Thank you. Is there any other disapproving of butters who wish to speak for the first time? Okay, other boards? None from other boards? Public at large? None from public at large? This is where the applicant gets a chance to rebut anything for the purpose of testimony given.
I would just like to address a couple of the issues that were raised. First is on that planning board decision. I'll be honest with you, I did not represent the Durgans during that period of time. They had other counsel, and it appears that their counsel did go to the planning board. One of the things that strikes me interesting about that particular decision is that
You mean the one here?
yeah, the one that you have that
Yeah.
Attorney Mueller had mentioned, is the planning board issued its decision at the September 27th, 2012 meeting. However, they did not supply a letter to that effect to the Durgans until February 11th of 2013, almost 5 months after the meeting. So it's unclear to me what happened there, why that would have taken almost 5 months to publish that letter.
Well, I frankly don't know, but I think if you were at the meeting,
I'm not clear that my
Somebody
clients...
must have been at the
I'm
meeting.
not clear who was at that
Okay,
meeting,
so-
to be honest with you.
well, let's put it this way. I'm reading what it says. This is.
Yeah, it says that it was at the meeting. It's just it's not clear to me whether the attorneys actually attended that meeting.
And I believe the letter says, on September 12th, and I where do you suggest that it was 5 months delayed? I don't see it in this.
The date
letter.
of the letter. It's February 11th,
Oh, sorry.
2013.
Wow. I don't know.
Yeah, I mean, I think that added to some of the confusion with the Durgans and their counsel as to what was happening at the time. With that said, one of the arguments is that they had this letter, so they didn't proceed in good faith. The fact of the matter is, the bulk of the work that they performed on that property was prior to the 2014 deadline.
I
So
think,
they were working in good faith to meet.
but if you have a challenge for the planning board, I think the minutes will stand who showed up at that meeting.
Sure.
And what was said. So, I mean, reading from
And
this letter.
I'm just saying, I think that there was some confusion
Okay.
in that period of time, given the length of time. And so when the Durgans were informed by their counsel about what had happened, I mean, they were moving forward. And as I say, the bulk of the work that they have done on this project was done prior to 2014. It was done before that deadline. So they were working in good faith. They were actually taking pretty substantial steps to try to complete the roadway. It just didn't happen. In terms of the 2008 amendment and the fact that after that amendment, that's what people should expect, this particular subdivision was on record at that time. So at least during that period of time, anybody who was interested in the subdivision would have been put on notice and could have
Wow.
looked at that
to be really technical about this, the planning boards puts on a sample warrant, posted, and by the way, when it's posted, it becomes law if it gets voted down at town meeting.
Correct.
So, we're splitting hairs here, but that was technically posted as a change of zoning. It's in probably December of 2007. And your planning board activities completion of the planning board took place after the town meeting.
But it
So-
had already been accepted at that point in time.
Yeah, I know, but if you go on the timeline, and I'm not a lawyer, I don't even play one on TV, but I'm told that when that posting goes up, it's effective of that date.
Correct. I
And-
believe though that their
And if
planning
it
board
votes
had
down,
been.
it goes away, but if it achieves the vote, it's backdated.
Correct. The reason that they weren't impacted is because as long as they had been accepted by the planning board prior to the posting, it doesn't,
Yeah, I just wanna
obviously
make a
hold.
point that it was publicly noticed that that was making a change.
Sure, and I guess my point is that people also had noticed that this subdivision had been approved. So it's not like it was a surprise. If you went to the registry, you would see that this cluster had been approved, and it is on the record. In terms of the comment that, at this point in time, the Durgans are trying to maximize their profit, the reality is they're just trying to make what was deemed a reasonable return. This was supposed to be their retirement. They've sunk all of their money, all their funds, all their work into it. They've been doing this themselves. As you know, they're contractors. So they've been working long and hard to do it, and they're not looking to maximize profit. They're looking to make a reasonable return, and quite frankly, not to lose money in this subdivision at this point in time. And just to, not that I think that it has any bearing on this, but just to, they did not lose their lawsuit, it was settled. The lawsuit that intervened, so they didn't lose that.
And the town was a party to that somehow.
I believe they were.
Somehow the
Yeah,
town
it
attorney got
was-
roped into this, I
They
don't know
did,
how.
yeah. I don't either, I don't even wanna know. It was from what I see, and obviously it's a 5-year lawsuit, it was pretty entailed. But they did eventually settle that. And then the only other point, I think I've already addressed it, but I'll just reiterate that in terms of like traffic concerns and all that, the planning board fully assessed that at the time of the subdivision approval. There's nothing to suggest that their considerations have changed. I understand the zoning ordinance has changed its lot size, but in terms of those considerations, they looked at those at the time, and there's nothing to change that today. Do you have any questions?
No?
I have a question, but I'm not sure if it's for her. I think it might be amongst the board, but,
Well,
yeah.
Peter, hold it for a minute.
Oh, yeah.
Thank you.
So, thank you. Would any of the approving abutters, which I don't believe there was any, would a disapproving abutter wish to rebut what the attorney said? Come on down.
Again, Daniel Muller for Candace Lehman and Barbara Kelly, and I will simply make a couple very quick points. There's been references to the planning board assessing things. They assessed that in 2007. We're talking now about 2015. That's my only point there. So say that, yes, they did in 2007. Now, obviously, you've heard from some of the people here that circumstances may have changed since then. And not to beat a dead horse, but on the vesting issue, again, I think the point is, one way or the other, they should have known that the deadline was coming. And in terms of doing the development, they continued on. Probably should have understood what it was going to take to get there. So again, for this, the good faith argument, I don't think stands here. That's it. Thank you.
Thank you. Other disapproving abutters wish to speak again on something new, not just the same. Okay, with that said, I'm gonna shut down the public hearing at this point. And that is, looks like 8:46. Is that 8:46? Yeah. It doesn't say that.
8:44, according to that clock.
Yeah.
8:45.
Trip changes that clock every day.
Okay,
It's a glare on
so this concludes the public hearing. From now on, it's up to the board to decide what we go to. And based on just receiving this letter and not having the opportunity for town council to review it, I think I'd like to recommend to the board that we continue the case, and I bring this letter and the rest of the material to the town attorney for, there's points of law here, which I don't pretend to necessarily understand the gravity of it. There's many references here for various case law, and I think it's important for the board to make a proper decision.
Again, if somebody wished to move to continue the case 0715, we're seeking town council.
I will make the motion to take case number 0715 and move it along to town council for an opinion.
Second.
Thank you. Discussion? Being none, all those in favor?
Aye.
Aye. Opposed?
No.
Being none? No? Okay. It's 4-1, unless somebody wants to vote twice, 0.
Is this going to be date specific?
It'll have to be the next meeting. Okay. So, for this evening, we're done with that case. It'll be, and do you have the date, Chip?
I'm looking. That would be December 8th.
Okay. Thank you. Yep. The first Tuesday.
Oh, it's the first.
It's the first.
December 1st.
December 1st.
Oh, God, those are the ones I forget.
Thank you.
Okay, who seconded? Who seconded?
I did.
Thank you, Mark. Thank you very much for all your time.
Bye-bye.
Thank you.
We need to run that off to our friend Bill. And I would send him down the new application.
He's already got it.
The new one or the old? Okay, well,
I've got some questions on that for you maybe later. You might be able to answer.
we don't want to talk about that case.
Yeah, no, I'm talking about procedure on involvement with the council.
Oh. Happy to do that. All right, we're up for the in all this is something. Okay. Oh, I need to change packages.
Changing people here too, right?
Yep, thank you.
I'm going out. and
Oh, okay.
He's coming in.
I was looking at
Oh, that's just,
Alrighty.
sir.
Get it?
Ready to go? Where you at?
Here's the map. What a chip.
Just so I can make sure I have it.
got it, Peter.
So this is, 0715 December. What was the date?
He's an alternate, non-alternate?
December 1st?
December 1st.
December 1st, yes.
We were. Okay. The last time we were here, the notice on the board, it differed in some people's opinion from what's was actually in the case. Correct?
Yes.
What was the remedy? Was it to correct the posting and keep the old application?
Yes.
Good, because this is
That is what we did. We used on the reposting, I used the exact wording
thank you.
on the application.
Except it says two single-family homes. Okay, just want to make sure, and the reason we did that, it may sound like an awful nit, but it'd be awfully easy for somebody to sue because due process was not provided for the general public. I didn't want to get into a lawsuit over procedure where it's pretty binary. It's either you followed the procedure or you didn't. There was a cloud on that, so I chose to kick the can, if you will. But we're here now. All right. Did we even get to accepting the application?
I don't think you did.
I don't think we even got that far. Let me find out where it is in my pile here. Here we go. That's not it.
Looking for this?
Yeah, but I don't. What's the cover? Just look at that. Ah, there you go. Yeah, I don't even see the package. See, my page is separate. So I'm trying to find the application. I got it from the last time.
There's one right there.
Huh?
Yeah.
Oh, that's yours?
Well.
Put this way. I can borrow somebody else's.
Is that it?
Give me all the pieces of it, so I can read it all. Okay,
There's a couple of them.
this is,
This is the right one.
Yeah.
no, this is the last one. Thank you.
Yeah, this is a lot. These are both.
Okay, I got it here. Okay, this is case 1215. The members who are sitting for this one is, we took Donnie away and put Mike in, okay? So those are the members for this evening's case. And, okay, there is an application. There is 5 points of hardship. And it's signed by Judith Schminty, dated 9/6/15. There is a authorization for Art to act on her behalf. There is a, looks like a subdivision highlighted. Also a sketch Also excerpt of the tax map. Deeds dated September 8th, 1978, and abutters. Very good. Okay. Motion to accept the application for hearing this evening.
Move to accept.
Thank you. Do I have a second?
I'll second.
Mike and Mark. Okay, discussion? Being none, all those in favor?
Aye.
Opposed? Being none, abstentions being none. Thank you. Any questions for the board before we ask Art to proceed? You folks all know what this thing is? You don't need to come up and look at the map?
Yeah, Ray, we heard anything about it.
Okay. Art?
Okay, so I'll give you the scenario here. There are 3 lots on Horse Spring Hill Road North, owned by Miss Trementi. They've never, all the other lots in the subdivision have been built on. These 3 lots have not been built on. She's owned them since 1978. We came to the zoning board once, I don't know how many years, a couple years ago, and we withdrew the application. Basically, I think at that time you wanted, as I remember it, you wanted some information on how we're gonna get to this property.
Well, we
But
asked
anyway,
if you had a design.
if we had a design,
First
okay, so,
consider.
and so since then, we've withdrawn. I've been to the fire wards, I've been to the planning board recently, and neither of them can give me an answer till I come for a variance. An answer to deal, to use this, or give me some input for their feelings on should we be able to use this, construct an access here. So we need a variance for the building permits. Then I can go to the planning board because the driveway, the proposed access to these lots is gonna be over. It's gonna be over, if we get a variance, then I'm just saying what I have to do after if I get a variance, yeah. And then still go to the fire wards and the board of selectmen for all those approvals.
They would be worried about the driveway access.
Right, okay. So, I've hired an engineer to do a preliminary design. It's preliminary because it's gonna be pretty expensive to actually design the construction of the driveway. And what he's done is come up with a grading plan. Mainly I wanted to see if we could fit this thing within the right of way. And he's come up with a design, it's there in front of you. And the grade getting in there is 15%. That's as good as you can do. It's very steep side walls that have to be constructed.
So, except for you come up to the town road.
Yeah, it's 2% for the first.
Then it tapers back to 15.
It's gonna go 15,
It
yes.
carries all the way through.
Yes, till we get onto the lot, down the hill, on a curve, into the lot. So that's how
And
we.
the second lot will have to have an extreme turn.
Well, not necessarily extreme, it could, I didn't show how the driveway is gonna get to the second lot.
Well, maybe you did. Isn't that it right there?
No, I did
What's
this,
that?
I added this on so because there was,
This gets to the first lot, correct?
and this would get to the first lot. The
This
second-
is your plan to go to the second lot.
Not necessarily, no. This is so that whoever wants to use this, it was mentioned that we were blocking this road off by doing this, and we would have been. So I came up with
Understand.
this,
Thank you.
so this could
Understand.
be used by others.
Okay, now I understand. So
That's-
you didn't show the two.
I didn't show it all the way in, I'm just trying to
Okay,
get down this
I
hill.
interpret that as being the
I
second
believe
lot.
that, I mean, I haven't checked the whole.
Okay.
So it's sloping towards the lot.
This is sloping through, it's
Yeah.
down.
I just can't see the number.
It's here and stuff.
Okay, thanks.
So, basically, that's it. We've come up with a design. Again, it's not a final design because of the construction materials that are gonna take. I mean, there is some drainage that crosses the road on Barnett Hill, that comes down onto Horse Spring Hill Road.
Show me on the map.
I don't show it on there, but it's there. There's a culvert right here. There's a culvert right there, and it comes down. The drainage goes like this right now. but we're gonna have to deal with this, deal with the drainage, bring it down, culvert it. We haven't, I haven't decided, we haven't figured out where it's gonna happen. It's probably gonna come down, culvert here, open, culvert, build a basin in there, fix it. So basically what's gonna happen, if this gets constructed, this portion of the road will be kind of useless as access. We won't need it because we're gonna grant an easement in this area so that anyone that wants to use this road can get there. You gotta come down here. turn.
Now we understand. Why don't you take us through your 5 points of hardship?
Okay. I guess that's where I'm at. 'Cause I think everybody's got the gist of what we're doing.
Mm-hmm.
Any questions? No questions?
No, go ahead. Question 1.
Okay, 1, that granting of the variance will not be contrary to the public interest because this will be an access for two, okay, wait a minute, let me just back up. So, you understand, we have 3 lots, we're gonna do away with 1, 2 lots.
You're gonna combine.
Because it's gonna be a shared driveway
Okay.
once you get onto the lots. And this is, I guess this is not really considered the driveway. The driveway is really
I understand.
on the property.
It's.
The other is
let me use
an
the
access.
term Access.
It's an access
Right.
as it approaches from Barnard Hill over Horse Spring, that's the access.
There are roads
The
and
driveway is
everything
on,
else.
and it's gonna be a shared drive, access drive.
Class 5 roads and everything else.
I gotta drive through it, so. Okay, so the, nope, let's see. Will be an access for 2 lots. No public funds will be used to construct the access. The design travelway will provide access for visitors, fire, and emergency vehicles. Number 2, the variance requested will not be contrary to the spirit of the ordinance because the area is zoned residential and building single-family homes on accessible travelway is not contrary to the spirit of the ordinance. The spirit of the ordinance is to address safety concerns associated with roads or accesses that are not maintained by the town. To prevent uncontrolled development. Neither of those concerns are relevant to this petition. That through granting of relief by variance, substantial justice will be done. These lots were created in 1971, along with 6 other lots. The 6 lots have houses on them. The owner purchased the 3 lots in 1978 and has been paying taxes since then. The proposal is to combine 2 of the lots, so there will be 2 lots sharing a common access. A variance with conditions will allow use of the properties as they could have prior to zoning. The access can be designed and constructed to allow access to the 2 houses. Number 4, that by granting a variance, the values of surrounding properties will not diminish because residential homes will be built on the lots, the same as the surrounding properties. Residential use in a residential neighborhood will not reduce values. Number 5, A. Describe the special conditions of your property that distinguish it from other properties in the area. Other properties in the area are on a Class 5 roads maintained by the town. These lots are on a Class 6 road not maintained by the town. That's the difference. 5I, no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property. Construction of a reasonably safe access to these lots is key to the use of these lots and solves the issue that the ordinance is concerned with. 5II, and how the proposed use is a reasonable one. The proposed use is for residential homes in a residential zone. By creating a safe access to these homes, the spirit of the ordinance will be met like other homes in the neighborhood. 5B. Please describe the special conditions of the property that distinguish it from other properties in the area. As noted, there were 9 lots created in 1971. These 3 lots are vacant and on a Class 6 road and in need of safe access. The other 6 lots have homes on a Class 5 road and have safe access. There are other homes in the area on a Class 5 road. And B, 5B, please indicate how, owing to the special conditions identified above, your property cannot be reasonably used in strict conformance with the ordinance, and a variance is therefore necessary to enable a reasonable use of it. 17.1.1 prohibits places a blanket restriction on all development on private and Class 6 roads because of the conditions of the roads. A variance is needed for access to and use of the property. Construction of an access way as designed will allow reasonable use of the property. The end.
Thanks, Art. Have a seat, please. Are there any approving abutters that wish to speak to this evening? Any disapproving abutters who wish to speak to this evening? Come on up. Come on, Ray. Ray, for the record, state your name and your address.
I'm Ray Dubois. I live at 566 Bonnet Hill Road. And I own from Bonnet Hill to River Road.
On the
On
north
the
side?
north side. Okay, I have the same map you have. And I'm very glad that Arthur actually mentioned that the plan was incomplete as far as drainage. And I truly believe that the issue resides with the culvert that has not been addressed, along with the historic site that is right on that corner.
So I understand. What historic site are you?
That's the Eaton Farm from 1850. Okay. The primary concern is public safety. The corner has been a terrible corner. It meets absolutely no highway requirements. You can only see looking north. If you were to look down Bonnet Hill Road, you cannot see west whatsoever. So it does no longer meet any of the requirements of the highway safety book. There are so many residents that live up there on Barclough and a number of other roads that have been improved in there. And there's lots of public safety issues that should be considered on that serious corner. And that's the number one complaint I have, is that we're not even looking at public safety here. We're looking at somebody's interest to put in a driveway onto that road, which would actually restrict my access to that road, because I have the same right to that, quote, Class 6 road as it stands from one end to the other to maintain my property.
Let me just make a very fine point.
Yes, sir.
The town owns the road. They choose not to maintain it, but they literally own the road. The selectmen own the road. They determine what goes on and on. You've had the pleasure of doing that. I'm not arguing that. I'm not suggesting they're ever gonna change their mind, but the road itself is literally owned by the town of Weare, run by the selectmen. That's just a fine point.
Point accepted clearly. It's never been clearly posted.
Was there ever a yellow sign about 4 feet square, 4x4, that has some language to the effect of you are leaving the town class 5 road?
Thought I
and
saw it.
going beyond this?
A while ago, quite a while ago, I thought I saw one up there.
No,
No?
no, sir. Back in 1981, there was no sign. And when the Army Corps of Engineers came in, they closed the road off at the River Road end.
They did that by virtue of making a 12-foot cliff.
Yes, and they also placed banks of dirt, like several banks of dirt, so that nothing or no one could go and drive over the cliff.
I guess the point is, it's a class 6 road which is determined as owned by the town, not maintained. That's the status of that road. I just wanted to be it's a fine point, but you have rights of passage, sub to the selectmen's purview. If they choose to let you, that's fine. I'm not suggesting they're gonna take it away, I'm just saying it's really up to the town's ownership.
I don't feel that the town is gonna take it away from me. I feel that
I get
someone else feels they can. And stop me from actually utilizing that to maintain my property from one end to the other.
Are you aware what he's suggesting, where this comes? He's, in his presentation, he's being magnanimous by saying, anybody that uses this road today that can't use it because that guardrail and that big steep hole up there, this hill, will have access using this road to come down on. So you'd actually have real access right now as a guardrail there. I just want to make sure you understood his
No, I
comment.
have a barway.
You have Bowway over here someplace.
I have a barway that's existing since the Eatons.
Where is the Barway on the map? Do you have an idea?
I have
Is it where the construction's proposed?
where they purposely proposed not to post it, and that's like right in there.
Well, your property's on that side.
Okay, so we have a barway that is not recognized.
How far down the road from?
20,
How far from here is it?
27 yards.
80 feet.
Yes, sir. So I am dropping in right from
Get
here.
over here.
Okay. Yeah, I'm going in at 27 yards. The culvert comes in right here, and that's totally gonna flood my property. And so where my confusion is how I can still gain access with this buildup when I look at those
Well,
elevations.
you're gonna be able to go down here and then go down that. We're gonna build an access like this.
Alright, how am I gonna get to my abutter's property? Who is unable to actually attend this meeting tonight, who's up here?
So you're gonna have to go by this road.
And when we do such a thing, I noticed in the past that everyone seems to be considering that now they have total ownership of that road.
Well, the town still owns it. They're asking,
We're gonna ask for construction, we're gonna go to the selectmen and ask to construct this on their property. After, if we get this variance, the next step is to go to other places.
right, this is his offering to the zoning board for consideration in his preliminary.
Correct.
I just wanted you to be able to see the map and understand exactly relevant to your land and your neighbor's land, how it's being used, and so That's what I really wanted to make sure.
This is where the historic land site is.
That's the old foundations.
That's the old foundations, the old Eaton farm from 1850.
But I don't think you're touching that, are you? Is it, which side of the rock wall is that foundations? It's on your side of the rock wall.
Yes, I do possess that.
So, okay, so I don't think, based on what I see here, they're gonna touch that anyway. There is one caveat, that he's going to have some engineering for drainage for the culvert.
Due to the fact that the culvert comes in,
Correct.
and right now the way the town highway department is directed, it is down the middle.
Correct.
We're gonna take care of it.
You're gonna take it.
It's not gonna go onto your property. Yes, that's the.
Cause
No,
that,
we can't send
Well,
it.
there is,
We wanna have a semblance of order here. I asked people to come down to make sure they understand what's going on.
Mhm.
I'd like you to go back to the podium, Ray, and, unless you wanna point to the map some more, and conclude your comments unless you have some new ones that you wanna bring up.
well, like I mentioned earlier, public safety is number one. Accessibility to that entire road that the selectmen owns, that everybody in this town or in this state has a right to use. I do not believe that someone should be allowed to take ownership of it and then claim ownership of it for their own personal financial gain. Because she bought property in 1978 and was delinquent enough not to do anything about it when she bought the property. And that's when there was a possibility that everything that would have been complied, could have been complied with, and would have been complied with by the town of Weare. But as soon as she just decided that she did not want to do anything about it, the problem really lies with not her accepting anybody's bids to own the property.
You mean to sell it?
Yeah, she was offered that,
But
but that's not.
I wanna say something. That's a civil matter between you and that individual. Nothing to do with the city thing tonight. We're based on facts on the map. So,
All right.
So, if you're at point of concluding your comments, I'd like to have you take a seat. Unless you got more comments.
Thank you very much, Mr. Chairman.
Thank you. Are there any other disproving abutters that'd like to speak? State your name, please, and where you live.
Peter Prue, 745 River Road.
Are you
I live down at the end
Are you a
of-
direct abutter to this property?
Yes,
Okay.
down at the end of, on River Road, where your famous cliff is.
Oh, do you own the cliff?
No, that's part of the road.
Yeah, but which side of the cliff do you own, the south side?
South side.
Thank you.
My only real concerns are, hardship points, it doesn't really seem to be any. She's owned the property since '78. She had 9 years, at least anyway, before zoning came into effect to
She had 10 years.
10 years. 9 years, really. But that's my one point on hardship. I don't really think there is one. Something should have been done within that period of time, ownership. When you get up top, I have no idea how you're gonna not spill over and make that spill over into the abutters property and make that safety vehicle friendly. And a 15% grade is not a safety vehicle friendly grade either. When you get up top of that hill, if you were to leave that driveway, you're blinded. You have no vision by anyone coming down Barnard Hill, a road, trying to get to River Road from that angle.
From that
It's
direction.
totally blind. You got a driveway to your left if you're coming out. Totally unacceptable, totally dangerous intersection. Take away those guardrails. The guardrails have already saved a few vehicles from rolling over and going all the way down that embankment as it is, without a guardrail there and with more traffic and safety concerns. Sooner or later, it looks like a fatality corner to me. Those are my concerns. Thank you very much.
Okay, let's see, there's no other boards or public at large in the room. All right. Want to rebut anything?
Well, yeah, I mean, the hardship is obviously pretty huge because she can't get to her property right now. And nobody else, nobody can really use that road. I mean, now people, with this, people will be able to use the road, the only people that really need it is Ray, and Ray's the only one that would use it.
No.
You got a chance to speak.
And, but anyway, we feel that she needs access.
What's the, how come the other direction wasn't considered?
That would be too difficult.
Is it worse than?
It would be, yeah.
It's a 12-foot.
If you're blasting ledge, you're gonna affect the properties, the abutting properties.
Yeah,
The stone walls, I mean, you're never gonna be able to contain
So those are
blasting.
your two
and-
options.
And then you're gonna dig a trench all the way up there. Now you got all this water going down onto River Road. At least the water that's crossing Barnard Hill can be captured and detained. And it'll really be better. Yeah, the other way. Everybody kept saying, go the other way, go the other way. I kept saying, no, it's not gonna work. But
You all set?
I'm all set.
Any members of the board want to talk that anymore? No. Ray, you want to have another rebuttal on something new based on his comments, or just the same old stuff?
Yes, I only wondered why nobody ever approached the Weares, which
Again, that's a civil
abut
matter.
that property clearly.
We're not here to solve those problems. We're here to hear a case for that access. That's it. Only. That's a civil matter. Now, what I mean by that is, it's decided outside of here, between two parties, nothing to do with the town way.
Yeah, because Worthley Road goes all the way up.
We understand.
So apparently I'm speaking out of turn and I'm
No, you're
very
speaking.
sorry.
No, you're speaking. I'm just saying that that's not relevant to the case. It's interesting, but it's not relevant to the next case. That may be a solution in the future, but it's not up for us to decide that.
Thank you, Chairman.
Okay, have a seat. Okay, that said, any other questions? Close the hearing? Public hearing? Thank you. Okay, one thing I did do is, I actually got the town of Weare I think it's 8.7 in some procedure, I think it's the fire wards, that actually define in great detail what they would consider for access from a Class 5 road. In this case, it's a Class 6, so it's from the Class 6 road into the lot. And their maximum is 10%. Their requirement, if the radius of this turn on this into the lot is over 45 degrees, it has to be 20 feet wide through that. So, I guess my concern is, And I know that the planning board have made exceptions for very short distances on roads that exceed, driveways that exceed 10%. But this entire thing, with the exception of the little area on the top, is 10%. That is excessive 10%, 15. And the radius is very sharp. There is 16 feet between the guardrails, but there's no accommodation for any water. Roughly from the, coming down from the feeder coming off down the road from Bonnet Hill. So there's a host of technical challenges that are lacking on this design. I really have a problem, because I realize you can't necessarily decrease the slope, but
The radius is 60 feet.
It's closed hearing.
well, the point is, it's gotta come out further, 20 feet.
What's that?
It has to be, a road has to be 20 feet wide. That's my point. There is no accommodation down this plan for any drainage, and that is an issue, because the road, by virtue of where it is, over the years of travel is, and erosion is the trough that it all runs down. So this plan, to me, does not satisfy a reasonable implementation. If this was a flat piece of property, this may have been settled earlier. We're not sure which way, but this has got significant challenges on it. That's my opinion on this. And
But it can be a
Yeah.
condition that it gets,
But
it gets designed. And if it doesn't get designed, if it can't be designed, you're talking about the drainage. And so the way I look at it is, if she doesn't wanna spend the money right now, I mean, you can send it off to go spend the money and then not get the variance, so we don't want to.
I guess my point is,
Mr. Chairman,
we closed the public hearing.
So-
Okay, that's my point. Thank you.
thank you, sir.
And I guess I, for one, don't like exercising applicants just for the sake of doing it for engineering studies. It's very expensive. But the whole issue hangs on how to make that. So the issues have been brought up this evening, and the issues of at least not even coming close to this implementation. And you want to put 2 properties on that road? So,
Mr.
I just
Chairman,
wanted to make that statement to the board before we go through the,
point of procedure, sir.
go ahead.
I'm not faulting Art for speaking out, but since he did speak out in a closed meeting, I think procedure would call for us to give anybody who has something to say to what he said, rebut it, to keep it fair. Just,
That's fine.
it's a technical thing.
I'll grant that. I don't think I have to, but I'll
Right.
grant this so we don't get a chance. Anybody want to speak based on our comment? If you don't, that's fine. I just want to get people up.
Thank you.
Thank you.
I believe Arthur has spoken the truth.
Thank you. Okay. With that said, I will accept question 1. Make sure I get everything in front of me here. Okay. Question 1?
Move to accept, question 1.
Thank you. Second?
Second it.
Okay, discussion. I guess my point, I'll do this in general discussion. I don't think the application before us meets the need. Some things are obvious on by inspection. This has got a lot of challenges, and I think before I feel comfortable that, and I know this is the only access, the only practical access for those 3 lots. I understand that. But other boards need to decide what they need to decide. We need to decide if this is feasible. And at this point, I have some reservations. There's some issues brought up regarding the road. That's a different problem, but it still has to be considered. The access, the drainage, the slope. I think it's an issue.
So I think part of the problem is we can't make a decision on that, knowing the challenges that are there, and we don't see any engineering addressing them.
Well, we can make a decision. The point is, you vote yes if you like it,
Well,
you vote no. So we're gonna make a decision. My concern is that I just see this as a technical challenge.
But if they wanna spend the money, then,
It's a different problem. I'm not suggesting they don't have a problem.
I understand what you're saying.
So-
I'm just,
I like to move on with the 5 points unless somebody else has another statement they want to make on the board. Okay. All those in favor? Opposed? No?
No.
Is gonna be an abstention? Is there noes? So is, I only counted 3 noes.
no.
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 Okay, 5 noes. 0, 5, 0. Okay, number 2. Motion?
Motion to accept.
I'll
Point two.
Mark moved and Mike second. Discussion? Being none, all those in favor? Opposed? No?
No.
Abstentions? 0, 5, 0. 3?
I'll make the motion to accept number 2.
Thank you. Second?
Aye.
Thank you, Mark. Discussion? All those in favor? Opposed?
No.
No. And abstentions? 4?
Make the motion to accept number 4.
Thank you.
Second.
Thank you. Discussion? Being none? All those in favor? Opposed?
No.
No. And abstentions? 0, 5, 0. Question 5 in its entirety?
Make the motion to accept question number 5 in its entirety, part A and B.
Second.
Discussion? Being none, all those in favor? Opposed?
No.
5 and abstention? 5, 0. 0, 5, 0. Now, you can't come before us unless there's some substantially different detail. Because you're not allowed to come into the same implementation. In this case, you came in with the same application, you fill it out. Chip would be obliged to.
If I came in with a full design, then
Let me say this, and it's an open-ended. You come with a full design that meets our concerns, and we don't know what the concerns
I don't
are.
have anything else to say.
Okay.
Yeah.
Okay with that? Thank you. All right. Minutes, we probably ought to take it next time because
I didn't get a copy of them. I got them in the email, but I didn't get a hard copy, and I didn't get it.
They're in this little package
They're in a
that I
package now.
delivered to you this
We'll,
evening.
Oh, you did? I'm sorry.
we'll correct that and do it next time.
Yeah, it's,
And do we have any extensions or anything, Chip?
No.
So we're basically good to go? Motion to
Motion
adjourn.
to adjourn.
Second?
second.
Thank you.